by deception from a person of the protected class for third-degree felonies. This matter is set for trial September 23rd. And the matter was set today for status hearing. And I've been presented with a plea of guilty form, Mr. Hartman, which is a 3-page form the prosecutor's office prepares. And on page 3, there are signature lines. And there's a line near the top of the page. I enter this plea voluntarily, and immediately below that there's a signature line, signature defendant, and it looks like signature John Hartman. Is that your signature I'm looking at?
Yes, sir.
Did you just sign this down there just a moment ago in courtroom?
I saw it signed the other day, J.D. Wagner.
Oh, you signed it the other day?
Yes, sir.
Okay. All right. Now, before you sign this, did Mr. Wagner go over it with you and explain it to you and answer any questions you had?
Yes, sir.
And when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial? The next step in the case would be a sentencing hearing.
Yes, sir.
And do you have enough time to fully consider this matter before making this decision?
Yes, sir.
Do you feel that you've been rushed or pressured in any way into doing this?
No, sir.
Are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
All right, now the agreement states you're going to plead guilty to count 1, theft by deception, in violation of section 2913.02A3, the 4th-degree felony. Further states that you understand that the maximum penalty for that offense could be 18 months in prison. The minimum term of the prison term imposed is 6 months. And there's a possible fine of $5,000. Do you understand that?
Yes, sir.
Other than this case, do you have any charges pending against you in any other court?
No, sir.
Are you currently on probation, community control, post-release control, parole, from any jurisdiction for a felony?
No, sir.
If you are convicted of this offense and sentenced to prison, once you complete the prison term imposed by the court, the law provides that the adult parole authority could, at their option, place you under what's called post-release control supervision for a period of up to 3 years, which means that you would be supervised on the term set by the parole authority, because the judge has no involvement in that, for a period of up to 3 years, and that would be by a parole officer with supervision. If during the period of time that you're being supervised, the parole authority felt that you had failed to comply, then they could return you to prison to make you serve an additional period of up to, in this case, 1/2 of whatever prison term the court ordered to be served for 1 or more violations. But if there's a felony conviction while you're under post-release control supervision, then an additional whatever sentence a judge will do against you for committing that offense while under post-release control in this case, to an additional period of 1 year. Whatever time is left on that 3 years of post-release control, whichever is greater, that occurred, that would have to be served consecutively with sentence in case. You understand that?
Yes, sir.
Under the law, I'm not required to sentence people convicted of this offense to prison. I can impose what are called non-prison or community control sanctions, which means that instead of being sentenced to prison, you would be put under the supervision of a probation officer for a period of up to 5 years under terms set by the court. Now, if during that period of time the probation department felt that you were non-compliant, they would file a written notice of that to the court, sort of copy upon you. You would be given a hearing, and if the outcome of that hearing was that you failed to comply, then at that time the court would revoke the community control and then sentence you to prison for 18 months and fine you $5,000. Do you understand that?
Yes, sir.
Now, the charge in count 1 alleges a period of May 1, 2019 through, let's see, there was an amendment. Was that to count 1 or count 2?
Amendment 1 was to count 2.
All right. So the date's right. All right. So I'll start over. The indictment states that on or about the period of May 1, 2019, continuing through May 1, 2021, in Highland County, Ohio, you did with purpose to deprive the owners, Jeremy Puckett and Daphne Kennedy, of their property, knowingly obtained or exert control over said property, to win $21,900 U.S. currency and other miscellaneous items by deception. Said property being valued at equal to or greater than $7,500 but less than $37,500. In violation of section 2913.02A3 of the Higher Revised Code. So that's the charge of theft by deception, a 4th-degree felony with possible prison term between 6 and 18 months and fine of $5,000. Now, Mr. Hartman, do you understand what it is you've been charged with by the state, what they said you did, when or how they alleged you did it?
Yes, sir.
You understand the possible penalties for that offense?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise in trial, possible outcome of your trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Have any threats been made to make you plead guilty here today? Now, on page 3, there are 3 sentences that are printed and bold and underlined, and they read as follows. Defendant shall enter plea of guilty to count 1. State will dismiss count 2. State and defense jointly recommend community control. Defendant agrees to make restitution to Jeremy Puckett and Daphne Puckett in the amount of $21,900 at $750 per month. Now, is that your understanding of the agreement?
Yes, sir.
And has anyone promised you anything to plead guilty here today?
No, sir.
Now, has the state consulted with both the victims, alleged victims, all 3, I guess there are here in this case?
Yes, Your Honor.
Right. In terms of what about the count 2, is there?
This will actually not out any money.
She's not out. Okay, so there's no restitution.
Correct.
All right. And so there is dismissed.
Yes, sir.
Okay. All right. And then the victims in count 1 have also been consulted about this disposition.